The Department of Justice just did something that has never happened in American history. And if you carry a concealed weapon, what they just filed could change everything about where you're legally allowed to go. In fact, this could be the single most important gun rights case since the Supreme Court's Bruen decision in 2022. Before we dive in, do me one favor right now, hit that subscribe button. Why? Because 90% of gun owners miss critical legal updates like this one, and when a ruling finally drops in this case, you need to know about it immediately. This affects whether you can legally carry in restaurants, banks, beaches, and thousands of other places. Don't be the person who finds out too late. Subscribe now. All right, here's what just happened. The United States Department of Justice filed an amicus brief with the Supreme Court of the United States. Now, you might be thinking, okay, so what? The DOJ files legal briefs all the time. But here's the part that shocked everyone in the gun rights community. This is the first time in American history that the Department of Justice has ever filed a brief supporting gun rights plaintiffs. In a Second Amendment case at the Supreme Court, let me say that again because it's that important. Never before has the DOJ stood up for gun owners at the highest court in the land. Until now. The case is called Wolford versus Lopez, and it's about Hawaii's gun carry restrictions. After the Supreme Court ruled in the Bruen decision back in 2022 that New York's concealed carry restrictions were unconstitutional, Hawaii had to change its laws. But instead of actually following the Supreme Court's ruling, Hawaii got creative, really creative. They passed a law that gun rights advocates are calling the vampire rule. And trust me, once you understand what this rule does, you'll know exactly why they call it that. Here's how the vampire rule works. In Hawaii, even if you have a valid concealed carry permit, you cannot carry your firearm on any private property that is open to the public unless the property owner gives you express permission. That means restaurants, stores, shopping malls, gas stations, banks, pretty much anywhere you'd normally go during your day. You need the owner's explicit approval, either in writing or with clear signage saying guns are allowed. If you don't have that permission, you're breaking the law. You could face criminal charges just for walking into a coffee shop with your legally permitted concealed firearm. Now here's the crazy part. This law flips property rights completely upside down. Traditionally in America, if you own private property, you have the right to tell people they can't bring guns onto your property. That's your choice as the property owner, but you have to actually tell them. You put up a sign, you make a policy, you communicate it clearly. Hawaii's law reverses this. It says guns are automatically banned everywhere unless the owner explicitly says otherwise. So instead of property owners having to ban guns if they want to, gun owners have to get permission before they can exercise their Second Amendment rights. Let me give you a hypothetical example to explain this. Imagine you have your concealed carry permit. You're running errands on a Saturday. You need to stop at the grocery store, grab lunch at a restaurant, and pick up some cash from the bank. Under Hawaii's law, before you do any of that, you'd need to call ahead to each location and ask if they'll give you permission to carry your firearm inside. Or you'd have to look for signage explicitly allowing firearms. If you can't get that confirmation, you either leave your gun in the car, which creates its own risks, or you just don't go to those places at all. Your Second Amendment right to carry for self-defense basically disappears the moment you leave your house. And it's not just Hawaii. After the Bruen decision invalidated strict gun laws in several states, lawmakers in California, Maryland, New Jersey, and New York all passed similar restrictions. They looked at Hawaii's vampire rule and said, hey, that's a great workaround. Let's do the same thing. So right now, millions of Americans in 5 different states are facing these kinds of restrictions. This case isn't just about Hawaii. It's about whether states can use this backdoor method to effectively ban concealed carry even after the Supreme Court said they can't. Quick legal note here. This is educational information, not legal advice. I'm breaking down what's happening in this case, but if you have specific questions about gun laws in your state, always consult an attorney who knows your situation. Okay, so back to the Department of Justice's brief. Attorney General Pam Bondi said in a statement, "As I said soon after taking office, the Second Amendment is not a second-class right. My Justice Department will continue to be the most pro-Second Amendment Justice Department in history." And they're backing that up with action. In their brief, the DOJ argues that Hawaii's restriction is blatantly unconstitutional. Those are their words, not mine. Blatantly unconstitutional. They say Hawaii is trying to evade the Supreme Court's Bruen decision by banning public carry through indirect means. The brief states, because Hawaii's law plainly violates the Second Amendment, this court should reverse the decision below. Now, why does the DOJ's brief matter so much? Because of their credibility. When the Department of Justice takes a position at the Supreme Court, the justices listen. The DOJ's arguments carry serious weight. And in this case, the DOJ is telling the court that Hawaii's law effectively nullifies the public carry right protected by the Second Amendment. Think about that. The federal government, as top law enforcement agency, is saying that Hawaii has found a way to completely eliminate a constitutional right. If you're finding this helpful, imagine what you'll learn in my next video where I break down the exact words to say when police ask if you're carrying. That video could keep you out of serious legal trouble. Subscribe so you don't miss it when it drops. But wait, there's more. The DOJ isn't the only one pushing back against Hawaii's law. 17 states filed their own amicus brief supporting the challenge to Hawaii's restrictions. Montana Attorney General Austin Knudsen led the coalition, joined by attorneys general from Alabama, Alaska, Arkansas, Georgia, Idaho, Indiana, Iowa, Kansas, Louisiana, Mississippi, Missouri, Oklahoma, South Carolina, Utah, West Virginia, and Wyoming. That's 17 state attorneys general all saying the same thing. Hawaii's law goes too far. In their brief, these attorneys general pointed out something really important. Hawaii tried to justify their law by pointing to historical restrictions on guns in certain places, but the historical evidence Hawaii presented is incredibly weak. They pointed to 2 local ordinances from specific parks in New York from the late 1800s, 2 parks. They also mentioned 1 Pennsylvania state law from 1868. That's it. And as the Supreme Court made clear in Bruen, a handful of localized restrictions cannot override the overwhelming evidence of an enduring American tradition of allowing people to carry firearms in public. 3 examples from over 150 years ago do establish a historical tradition that justifies banning concealed carry in restaurants, banks, and beaches today. Hawaii also tried to argue that the restrictions on carrying in banks and financial institutions are similar to historical regulations that prohibited guns at fairs and markets. The district court rejected that argument, and rightfully so. A bank is not a fair. A credit union is not a farmer's market. These are completely different places with completely different purposes. You can't just pick random historical restrictions and try to apply them to modern locations that have nothing in common with the historical examples. Here's what most people get wrong about this case. Some gun owners think this is just about Hawaii, and since they don't live there, it doesn't matter to them. But that's a huge mistake. If the Supreme Court allows Hawaii's law to stand, every state with strict gun control will immediately copy it. California, New York, New Jersey, Maryland, Massachusetts, Illinois, and more. They'll all pass vampire rule laws. Overnight, concealed carry will become practically impossible in states where more than 100 million Americans live. This case sets the precedent for the entire country. And here's the part nobody's talking about. If states can use this property rights flip to ban concealed carry on private property open to the public, what stops them from expanding it? What if they say, you also need express permission to carry on any public sidewalk that passes by private property? What if they require written authorization to carry within 500 feet of any private business? Once you allow the government to flip the default rule like this, there's no logical stopping point. They can keep expanding the restrictions until the Second Amendment is completely meaningless. The Supreme Court heard oral arguments in this case on January 20th, 2026. That was just last week. During those arguments, the justices asked tough questions to both sides. They're trying to figure out where to draw the line. How much can states restrict concealed carry in the name of public safety? When does a restriction become so broad that it violates the Second Amendment? These are not easy questions, but they're critical ones, and the answers will affect gun owners in every state. Here's a crazy stat. Only 12% of people watching this video right now are subscribed to this channel. That means 88% of you are at risk of missing the update when the Supreme Court issues its decision in this case. And trust me, you want to know immediately when that ruling comes down. It could change gun laws across the entire country within hours. Hit subscribe right now so you're part of the 12% who stay informed. Now, there's another important angle to this case. The DOJ also got special permission to participate in the oral arguments. That's extremely rare. Usually only the actual parties to the case get to argue before the Supreme Court. But the justices granted the Solicitor General's motion to participate as amicus curiae, which means friend of the court. The DOJ got time to present their arguments directly to the justices. That shows you how significant this case is. The Supreme Court wanted to hear from the federal government about whether Hawaii's law is constitutional. Let's talk about what happens next. After oral arguments, the justices meet privately to discuss the case and take a preliminary vote. Then, one justice is assigned to write the majority opinion. Other justices might write concurring opinions if they agree with the result, but for different reasons. And justices who disagree will write dissenting opinions. This process takes time. We probably won't see a decision until sometime in June 2026, when the Supreme Court typically issues its biggest rulings of the term. But when that decision comes, it's going to be huge. Here's what could happen. Best case scenario for gun rights: the Supreme Court strikes down Hawaii's law and makes it clear that states cannot flip the default rule on private property. The court says that property owners have the right to ban guns if they want to, but the default rule is that concealed carry permit holders can carry unless they're told otherwise. That would be a major victory and would invalidate similar laws in California, New York, New Jersey, and Maryland. Worst case scenario, the Supreme Court upholds Hawaii's law and says states have broad authority to designate sensitive places where guns are banned. That would greenlight even more restrictions and would effectively gut the Bruen decision. States would rush to pass vampire rule laws, and concealed carry would become nearly impossible in blue states. Most likely scenario, the court issues a narrow ruling that strikes down some of Hawaii's restrictions but allows others. Maybe they say restaurants and stores are off limits for blanket bans, but certain truly sensitive places like schools and government buildings can still restrict carry. This middle ground approach would give some wins to both sides, but would also leave a lot of questions unanswered. This information could literally change after the court issues its ruling, which could happen any day between now and June 2026. Subscribe now because the next video will break down exactly what the decision means and what you need to do to stay legal. Don't wait. Click that button. Let me tell you why this matters on a personal level. Self-defense situations don't happen at convenient times or convenient places. They happen when you're going about your normal life. You're at the grocery store and someone tries to rob the place. You're at a restaurant and an active shooter walks in. You're at the bank and an armed robbery goes down. These are exactly the kinds of places where law-abiding citizens need the ability to defend themselves. But under Hawaii's law and under similar laws in other states, you'd be committing a crime just by having your legally permitted firearm with you. You'd have to choose between being defenseless or being a criminal. That's not a choice Americans should have to make. And here's something else to think about. Data shows that concealed carry permit holders are some of the most law-abiding people in America. In Texas, permit holders are nearly 7 times less likely to be convicted of a crime compared to the general population. In Colorado, they're more than 8 times less likely to be arrested. License revocations are incredibly rare, typically between 0.01% and 0.32% annually, and often those revocations aren't even related to criminal conduct. Concealed carry permit holders are exceptionally responsible. Yet Hawaii's law treats them like dangerous criminals who can't be trusted to walk into a coffee shop without explicit permission from the owner. That's not based on evidence. It's based on fear and hostility toward the Second Amendment. So here's what you need to know right now. If you live in Hawaii, California, Maryland, New Jersey, or New York, pay very close attention to this case. The Supreme Court's ruling will directly affect your ability to carry concealed. If you live in any other state, this still matters because the precedent set here could eventually affect you too. And if you care about the Second Amendment at all, you should be following this case because it's one of the most important gun rights cases in decades. The bottom line is this. The Department of Justice has taken a historic stand for the Second Amendment. 17 states have joined the fight, and the Supreme Court is now deciding whether states can use clever legal tricks to ban concealed carry even after being told they can't. This is happening right now. The arguments have been made. The briefs have been filed. And sometime in the next few months, we're going to get an answer that shapes gun rights for generations to come. Look, I spent hours researching these cases, reading legal briefs, and breaking down complex court decisions so you don't have to do all that work yourself. The least you can do to support this channel is hit the subscribe button. It's free. It takes 1 second, and it ensures you never miss an important update like this one. Do it now. Here's what I need you to remember from this video. The Wolford versus Lopez case is about Hawaii's vampire rule that requires express permission to carry on private property open to the public. The DOJ filed a historic brief supporting gun rights for the first time ever at the Supreme Court. 17 states have also filed briefs challenging Hawaii's law. Oral arguments happened on January 20th, 2026, and we're waiting for a decision that could come any time between now and June. This case will determine whether states can effectively ban concealed carry through backdoor property law restrictions. And whatever the Supreme Court decides will affect gun owners across the entire country. Laws change fast in America, especially gun laws. One court decision can flip everything overnight. You cannot afford to miss these updates. Subscribe to this channel right now so you're always in the loop when major Second Amendment cases get decided. Your gun rights literally depend on staying informed. That's all I've got for you today. Remember, this is educational content to help you understand what's happening in the courts. It's not legal advice for your specific situation. If you have questions about gun laws where you live, talk to a qualified attorney who can give you personalized guidance. Stay safe, stay legal, and stay informed. I'll see you in the next video where we break down what happens after the Supreme Court issues its ruling. Hit subscribe, and I'll catch you next time.